Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you. And good morning, everybody. Happy Friday the 13th. It's Friday, March 13th, 2026. And this is one of two panels of the appeals courts that's sitting today. I know the attorneys who are in the room know that they're in the right room, but for those watching on YouTube, if you want to see Justice Rubin's session, it's on the other channel. Your panel for today is me. I'm Greg Massing, Justice Savita Singh to my right, Justice Marguerite Grant to my left. We have read your briefs, and we have them on these handy tablets. So if you see us looking at the tablets and not at you, it's because we're looking at case materials, not headlines or sports or stuff like that. 15 minutes per side, no rebuttal. At 13 and a half minutes, the yellow lights goes on. It means you have a minute and a half left. At 15 minutes, the red light goes on, and then it starts counting up. So it looks like you still have time left, but if the red light is on, that means your time is up. We might let you finish what you're talking about, though. That said, if you don't take the whole 15 minutes, that's fine, too. There's no penalty for finishing early. Okay, so the first case this morning is 25P477, Commonwealth versus DEPERSIS.
Good morning. May it please the court. So my first argument in this case challenges the constitutionality of the pre-22 Massachusetts licensing scheme. I recognize that this facial challenge was addressed in the Rodriguez case, which came down shortly after I filed my brief. I did file a reply in this, and I'm certainly not waiving any of the arguments I make there. However, I understand that based on Rodriguez, the court is unlikely to rule in my favor as to the facial challenge to the statute. So with that in mind, I would like to move straight to my second point if that is all right with the panel. So my second point is that this jury instruction regarding constructive possession, where the jury was instructed that through another could be the basis for a conviction, was erroneous. I recognize that this is not a joint venture case. I'm trying to not conflate the two. I understand they're different. What I'm trying to argue is essentially that this through another phrase in this context where licensure is at question creates a pathway, a confusing pathway to the jury where they could convict the defendant, my client in this case, for otherwise lawful conduct. In other words, they could find that through another, without further instruction, the co-defendant could or could not have been a lawful gun owner, and they could have convicted my client based on that.
Well, let's just tease that out a little bit. Suppose I'm a felon, say, and I can't own a gun, and I want to rob a convenience store, and I decide to drive to the store, and I bring with me a friend of mine who I know has a license, and I say, I have this gun here. While we're driving, you hold on to it, but when we get there, give it to me. Does he not have constructive possession over that, and illegally?
Yes, Your Honor. So, yeah, that's sort of like in the jury instruction when they talk about even like the safety deposit box or something, like someone in care of your what is actually yours, and that in this case, as you're explaining, it would just create some sort of legal loophole. However, in that case, first of all, there is unlawful conduct by the defendant where they do ultimately actually possess the weapon, and the other aspect of that is that.
But no, suppose they get caught.
Sure.
But he get pulled over before, and the licensed guy has the gun, and the licensed guy says, "I'm just carrying it for him because he wants to rob the jewelry store."
Sure. I think that would be a factual question, and in that case, the jury would still have to find.
Would it be illegal? Would the driver be illegally possessing the firearm? through another?
Yes, if they were asking someone to carry it for them just to avoid the licensure statute, I think that would be illegal conduct. I think the point here is that there was potentially confusion as to what the jury could convict on. And the prejudice aspect of this is the fact that it wasn't clear. There was evidence as to both people possessing the firearm. However, there was not a continuous chain of observation by the witnesses. There was different testimony by each witness as to who actually possessed the firearm. There's different testimony as who could have fired the weapon. And in the end, the officers arrive on scene, and we do know who was in the passenger seat and the driver's seat when the officers arrived. But there is this sort of ambiguity as to who possessed it. So the danger lies in, without further instruction, that the jury could find.
Let me ask you this, though. The jury, it so happens, found that both men were unlicensed, beyond a reasonable doubt. So even if there was an error here, isn't it harmless because the jury's going to find that both men don't have a license?
Well, I guess the problem is within the ambiguity here, and we don't have specificity as to what the jury exactly found. So without this clear instruction, the ambiguity allows a pathway to conviction through otherwise lawful conduct.
So when you talk about ambiguity, it sounds like you're saying there should have been a specific verdict slip as to whether or not the defendant possessed the gun by joint venture or himself?
Well, I don't actually argue specific unanimity in this case. Certainly, it probably would have been helpful. However, what I'm constraining my argument to is the fact that this part of the instruction, although part of the model instruction, in cases of gun licensure, can be confusing to the jurors. With that, I will move on with no further questions on that point to my third argument, where, so under Smith, the SJC found that the CJIS information that comes in against the defendant is only relevant if there's something tying that search, those identifiers, to the defendant sitting before the jury. Now, that happened in this case. However, the problem is that only happened via redirect.
Would it be a different story if it happened after the Commonwealth rested and then asked for permission to reopen the case?
Yes, I do recognize that the Commonwealth can do that, and put in a position here where it seems inevitable that the Commonwealth could have reopened the case or something like that and just proved it that way. However, in this case, there was absolutely no evidence of the date of birth that came in on direct, and they only supplied that link, that critical link between the later CJIS testimony and the defendant sitting before them via a redirect.
What's your best case that says a judge does not have discretion to allow redirect that's beyond the scope of cross?
Your Honor, unfortunately, the cases are not friendly to this argument. The redirect is, mostly in the discretion of the trial judge. Even the Rodriguez case that the Commonwealth references with the school zone obviously is a critical element of that offense, and it's applied via redirect. I'm stating that in this case that rather than a part of the possession charge, which is the school zone, this is a critical element between other testimony that links an element of the crime, the non-licensure statute, to the defendant sitting before them, and that was the error. I understand that this is a situation where the judge could allow the Commonwealth to reopen. However, this is about a trial process, and the fact that, redirect should be constrained to what was elicited on direct. The redirect is supposed to be for clarification purposes. Without some sort of constraint on that, anything is fair game on redirect here.
So it sounds like you're not really arguing an abuse of discretion. You're saying that it really should be sort of a clear-cut that the judge didn't have the ability to do that.
I recognize that the case law says this is purely abuse of discretion standard, and I am saying that in this case it wasn't abuse discretion. It was a bridge too far. They didn't open it up at all. It was purely just coming back and, they refreshed the recollection of the officer, and then the officer, read the date of birth essentially from the police report. So this critical link to later testimony to prove a fundamental element, the lack of licensure of this case, was provided solely via redirect.
But your brother says that the way you determine whether it was an abuse of discretion or not is to determine the prejudice.
Yeah. So, of course, yeah. So the prejudice here would be if that was not allowed. Obviously, potentially the Commonwealth could reopen the case, but we don't know what they would have done. What we do know is if this information was not available to the jury, they could not create that causal link. What the Commonwealth could have done after the fact is not in the record here. So with that, I will finally move to my fourth argument, where I talk about the fact that the motion to sever pretrial was not allowed in this case. This is a case where two defendants were convicted of possessing a firearm in a vehicle. The factual record is unclear as to who possessed. It's not clear as to whether they were both in possession, or maybe one was and the other one was found guilty of constructive possession. That is left open here. And while the trial strategy at trial was not a mutually antagonistic sort of defense, they both just sort of said they didn't prove who had the weapon, right? They were not allowed to pursue any sort of, strategically it was made much more difficult for them to pursue a mutually antagonistic defense where they were not severed prior to trial. The motion to sever puts forward the fact that theoretically they would have pursued this. However, with the denial of that motion to sever, they were forced to sort of try the case side by side, and practically speaking, you're sitting next to your co-defendant, and rather than making the jury make a choice between who to choose or just throw up their hands and say both,
the fact that the motion was denied, what prevented trial counsel from blaming McDougal?
So that's something that a lot of these cases talk about, the severance, and nothing actually prevents them from doing that, right? Like it is technically available to trial counsel.
It's the classic prisoner's dilemma, right? Like you maybe you blame the other one and you both get it. I don't know.
Yeah, it puts trial counsel in a very difficult position of putting forward an argument with the co-defendant sitting right next to you where you're pointing the finger. And then it puts them also in the difficult position of whether their client testifies or not, knowing not just that the Commonwealth is going to be cross-examining them, but also their co-defendant's counsel will be cross-examining them with everything they know about the two in the process. So it does create sort of difficulties in the right to testify for the client as well. But fundamentally, it did hamstring defense counsel in terms of strategically what would make the most sense in terms of when they brought the case to trial. So for those reasons, I think the motion to sever should have been allowed. Seeing no further questions, I'll rest on my brief. Thank you.
Thank you. We do appreciate your candor and doing your best job for your client.
Good morning, Your Honors. Assistant District Attorney Matthew Padalano on behalf of the Commonwealth. Your Honors, I won't discuss much the facial challenge issue. I think the SJC's ruling is, sure.
And you found Rodriguez footnote 8.
Yes. And I believe that the issue of whether or not there is a residency or non-resident is relevant to the court's ruling because it will have to write this out and why this is not an issue. But either way, I believe the issue is settled pretty distinctly. And unless there are issues on that point, I'd move on to the...
I was just a little curious that you actually conceded the clairvoyance argument. I mean, aren't you being a little bit kind? Bruin was decided already. Bruin basically said Massachusetts is one of 6 states that does it wrong. You don't have to be clairvoyant to say that we should apply Bruin now.
Your Honor, I very well could have argued the clairvoyance issue. I think, given that the other issue is dispositive, pretty clearly and pretty directly on point, I didn't find that it was worth spending the pages in my brief to discuss that issue. And I think maybe it was a little bit kind, but I think the SJC ruling being directly on point and facial challenges not being fact-specific, I think deal with that issue pretty succinctly. If there are no further questions on that, I'd move on to the issues the SJC has not already ruled on. So the first issue is the constructive possession issue. I understand the defendant's argument that he's not conflating joint venture with constructive possession. However, if you look at the substance of what he's arguing, he's essentially arguing it was under some joint venture theory. He argues the jury was confused about whether or not it was principal liability or possession through another. To be clear, the jury found the defendant guilty of possessing it himself. Now, whether or not he is possessing himself through another or not, it is still principal liability. And the Severino case says, for principal liability, the Commonwealth must show the defendant lacked a license. For joint venture, that the co-venture lacked ones. That is the key distinguishing thing between joint venture and principal. And for that reason, this issue is relatively straightforward. This was a theory of principal liability. The issue is whether or not the person who is in possession of the firearm did not have a license, and the Commonwealth proved that. And as Judge Massing pointed out, regardless, even if this court rules otherwise, the jury found that neither individual had a license. And so even assuming that the defendant's argument had any merit, there's no prejudice here. If the court has no questions on that issue, I turn to the next issue. So as to the redirect examination, a different Rodriguez case, this is the appeals court Rodriguez case, directly establishes that having an essential element proven on redirect is not an abuse of discretion. And that's a practical reality, because in this situation, I would like to take the court through what might have happened had this request to talk about this on redirect been denied. The Commonwealth would have allowed the police witness to get off the stand and then could have asked, can I please recall the police witness? And then he would have gotten back on the stand and been able to establish the element that way. So this is simply a practical reality of, until the Commonwealth rests, they're allowed to present their case, and whether or not that's through the witness getting on the stand once or twice makes no difference. And there's no case law that says otherwise.
So is it sufficient to establish the defendant's date of birth for the DEPERSIS search to basically read a police report into evidence? I mean,
I'm not sure I understand.
I know there was no objection as far as the present recollection refreshed, but the officer doesn't have personal knowledge of the defendant's birthday.
Sure. So he did at one point have knowledge because he obtained it, and then he had his knowledge refreshed. I understand that refreshing of recollection is a little bit of a legal issue, but in this case, he had testimony that said, my recollection was refreshed, and then testified to his own recollection. Now, obviously, that could have been objected to. It was not.
Would it have been in the judge's discretion if the defense had said, oh, come on, his reflection isn't really refreshed. This was however many years ago, and he's heard so many birthdays. Would it have been the judge's discretion to say, I don't believe his recollection is refreshed, you've got to prove it some other way?
Yeah, so I believe, again, this is an abuse of discretion. Whether or not that would have been an abuse of discretion, I don't know. But the issue is whether or not what the judge actually did was an abuse of discretion. And here it was well within their discretion to credit the officer's testimony that their recollection was actually refreshed. Many things are recorded, and then that recording allows someone to bring that memory back to the forefront of their mind. And that's why we make these kinds of recordings, is so that the recollection can be recorded and then later remembered. And I will also say I don't know that the argument in the brief rises to the level of an appellate argument. It's a very quick aside and without much legal citation. If there are no further questions on that issue, I would turn to the severance issue. I understand that we are looking at things in a retroactive lens. That's relevant for two reasons. One, it shows what the defendant's actual defense was, not what they posited it might be. And that's relevant not only to whether or not this is erroneous, but also if it was erroneous, what kind of prejudice the defendant experienced because of it. And so if the court finds that there was no error, that's one reason not to get a new trial. But also if there was no prejudice, that's another reason to not get a new trial. And here, the issue is whether or not they were mutually antagonistic defenses. So it's whether the sole defense of one is the guilt of the other. In this case, the defendant's defense was essentially the Commonwealth has failed to prove or meet their burden. Their defense was, why would anyone sit in this car, shoot a gun, and then sit in the car and wait for police to arrive? That was their defense. And their defense was symbiotic and worked together.
I mean, you mentioned looking at it retroactively. How do you respond to Attorney Dashner's argument that that's what they were stuck with doing? We don't know what they would have done if it had been severed.
Sure. So I think that is a valid argument. However, the case law is very clear that the prejudice, we are forced to examine what was actually elicited at trial. Now, had there been some affidavit from defendant in a motion for new trial context that, well, I pursued this defense because the other defense was unavailable to me because we were, I forget the nuclear arms term, but where there was a conflict where we both agreed not to sort of point the finger at each other. If there had been some affidavit from counsel that said we had come to some agreement about that, or there was the prisoner's dilemma, as you pointed out, we might be in a very different posture, but we are stuck with the trial record that we have.
You say that the case law is clear, that we look at what actually happened. What's the clearest case that says that?
So I would point to Vasquez. And that's the case that says severance is required only if the defenses are both mutually antagonistic or mutually exclusive and irreconcilable. And I understand that that's a general assertion. I don't have a good case law that has facts parallel. My apologies if I overstated. But in this case, I believe that the defenses were both consistent with what they purported the defenses would be and are not mutually antagonistic. The defenses are the Commonwealth has failed to prove that either party knew about the gun under the seat. It could have been some third party who put the gun under the seat. Who knows? It's not logical that they would just sit there and wait for the police to arrive. Those were essentially the defenses, and they are to the benefit of both defendants. And I think if we're left in a world where we have to conjecture about what the defenses could have been, I think that's very different. And there are obviously also many shortcomings that come with putting the defendant on the stand. He would be subject to cross-examination, and so there are many logical reasons other than essentially forcing the other defendant to testify as to why a defendant might not testify. And the court has no record of why the attorney did not have the defendant testify or suggest the defendant testify.
So you're saying he may be able to make the argument, but not on this record?
Not on this record, that's correct. And again, the defense attorney was welcome to bring this up again at the close of the Commonwealth's case and say, we are forced in this position once again, based on what we've heard. Our only option is to point the finger at each other. Had he brought that up, maybe he could have established a record at that time. But on the record that we have here, it's not clear that this was actually the defense they were planning to pursue. If the court has no further issues on that question, I would rest on my brief and ask that the court affirm the defendant's convictions.
Seeing none, thank you both. Well argued, well briefed. Case is submitted. So, by the way, we're taking the cases in the order that they're on the list. We're going to hear the second case now. If you're fourth or fifth or sixth on the list, you feel free to step out if you need to. Second case is 25P929, Commonwealth versus Neves. Maybe it's Neves. How would you pronounce it, Attorney Power?
My client's name, Nieves.
Neves, okay. I got it right the first time.
You almost got it. All right, good morning, Your Honors. May it please the Court, Andrew Power for Defendant Kevin Neves. I'm going to begin with the three factors that the jury did not hear about at trial that we feel were very important for the jury to hear, and their absence was prejudicial to the case. First, there's Mr. Rodriguez's admission that he shot the victim. In particular, the phrase at 13:47 on the video, "Nobody knows it's me. They blame it on KD." So not only did he say that my client was not the shooter, he also said that
How
nobody
does
knew.
that say that your client is not the shooter? I mean, it's, okay, even assuming it says that your client's not the shooter, does that preclude his guilt as a joint venturer?
That particular phrase does, because his guilt as a joint venturer would be predicated on knowledge of that the shooter in this case, Mr. Rodriguez, had a gun. And if Mr. Rodriguez is saying, nobody knows it's me, they blame it on KD, nobody presumably includes KD. KD doesn't know it's me. KD doesn't know that I had a gun. That goes to my client's knowledge of the weapon under a joint venture theory.
Why would it be presumably KD? Wouldn't it be presumably the police, the authorities?
Well, then he would say the police don't know it's me. If he were, let's say that KD knew that he had a gun. KD has just been arrested for his crime. He would probably be saying something to the effect of, KD knows it's me, nobody else does. Right? Because if he knows that KD knows, the natural thing would be to say that. If he's saying nobody knows it's me.
What about the fact that
The
somebody
understanding-
yelled, "We'll start shooting"? Doesn't that show the defendant's knowledge that more than one person had a gun?
For the sufficiency of the evidence, yes. For the weight of the evidence, no. And I think the whole point of get out of the truck or we'll start shooting is who says it? Jacob Blanchard says it. Are there problems with Jacob Blanchard's testimony? Yes.
Before we get to Blanchard, which I know you want to, that's 2 and 3, help me with if your trial counsel had this smoking gun exculpatory evidence, why didn't he use it?
He didn't use it. He said, we produced an affidavit of counsel, submitted it to the judge. He said he didn't use it because the prosecutor said that this evidence would come in, that the Commonwealth would concede, as it did at the first trial, that Rodriguez was the shooter. And he took that at face value and didn't prepare to introduce the evidence. Now, this evidence...
I mean, as soon as the closing argument, as soon as opening statements, wouldn't he know that I better get prepared? I mean, so are you arguing ineffective assistance, or are you arguing prosecutorial misconduct? What are you arguing?
That would have to be determined in an evidentiary hearing. We're arguing what appears to be ineffective assistance, but it may be affected by prosecutorial misconduct in 2 areas. Not only did the prosecutor, if counsel is to be believed, lead counsel to believe that the Commonwealth would concede that that Rodriguez was the shooter, the prosecutor did not inform counsel of the fact that Blanchard recanted at a subsequent trial.
Well,
2 months later.
how could he? They couldn't tell him that he's going to recant 2 months from now.
No, but after the fact, he could have notified him.
So are you saying that word skeptical is a recantation?
In this context, yes. I think we could call it a retraction, a recantation. It's also false testimony because he said, I'm skeptical about it, and I said that at the previous trial, which is a false statement. He did not say at the previous trial.
What do we do with the fact that then when Rodriguez's lawyer got up at page 891 of the record appendix and says to Blanchard, you do mention seeing a gun, correct? Correct. You saw the gun in Mr. Nieves' hands, correct? Correct. So if we were to agree with you that that reference to having been skeptical and made his skepticism clear at the prior trial was something that deserves a new trial, wouldn't the Commonwealth be able to rehabilitate Blanchard with this testimony?
Well, the problem is Blanchard really is in need of rehabilitation because he's changed his story so many times. At first, he told the police Neves didn't have a gun. Then he changed that story to Neves did have a gun. Then he stated at Neves' trial that Neves had a gun, and he was questioned about it, pressed on it, and he said, yes, I had to check. I wasn't sure, but now I'm sure. And then he changed his story again at Rodriguez's trial. So he certainly would need to be rehabilitated, but I think that goes to Blanchard's credibility and total lack of credibility, which did not come out at Nieves's trial. At my client's trial, Blanchard was presented as a fairly truthful witness. He wasn't impeached with his bias based on the home invasion charges. He was not impeached with the fact that he changed his testimony at Rodriguez's trial.
Sorry, what, he wasn't, didn't defense counsel ask him about being charged and not, being involved and not charged with the home invasion in cross-examination? You just said he wasn't, you said it wasn't brought up.
Excuse me, Your Honor. What was the question?
I mean, it was brought up, right? He was cross-examined with
sufficiently brought up. The transcript shows that trial counsel asked Blanchard whether he was charged whether he was involved in a home invasion. He denied it. He said, I didn't go in. Counsel left it at that. He asked the trooper, was he charged? Was he a suspect? Yes. Was he charged? I don't have anything to do with charging. The trooper wasn't involved in the charging decision. Counsel did not call the most important witness, ADA Giarolo, who Judge Agostini found made a discretionary decision not to charge Blanchard, despite the fact that there was probable cause that Blanchard was involved in that home invasion.
So if you're arguing that there was an undisclosed deal with Blanchard, shouldn't you have, with your motion for new trial, submitted an affidavit of any attorney who represented Blanchard and/or the prosecutor who negotiated that undisclosed deal?
I'm not arguing that it's an undisclosed deal with Blanchard. I'm arguing that Blanchard was biased. He had a reason to curry favor with the Commonwealth because, actually, under the statute of limitations, the Commonwealth could still charge him with home invasion at the time of trial. The home invasion occurred in 2018. The trial occurred in 2022. He was still exposed to those home invasion charges.
So if he's cross-examined, not long after this incident, you were a suspect in a home invasion case, is that correct? Yes. You were not charged? No. It's really important that you give powerful testimony in this case. How would it help the defendant to then put a prosecutor on the stand to explain why they didn't charge Blanchard in that other home invasion?
It would help because they could say, was there a witness who saw Blanchard in the house? Yes. Did Blanchard tell police that he remained at the scene throughout the home invasion? Yes. Did Blanchard tell police that he had a beef with the alleged victim? Yes. Why wasn't Blanchard charged? Well, we made a discretionary decision not to charge him. You can leave it there for the jury. They can draw their own conclusions, as Judge Agostini did, that this was certainly favorable treatment, prosecutorial favoritism shown towards Blanchard based on his participation in this case, because he was the star witness. He was a crucial witness. And without his testimony, the case against Mr. Nieves, my client, would have been a lot weaker. So let me talk about some of the judge's findings that we believe are clearly erroneous in his denial of my client's motion. And let me make it clear that all I'm asking for at this point really is an evidentiary hearing. We want to go before the judge. We want him to hear the evidence. We want him to hear from trial counsel. We want him to hear from the prosecutor. And we want him to make findings of fact based on the testimony. And I think a lot of the questions may be answered about whether trial counsel was ineffective or whether it was some combination of prosecutorial misconduct, ineffective assistance, and perhaps newly discovered evidence that trial counsel did not have access to. This falls under the rubric, and I'll return to the judge's findings in a minute. But this falls under the rubric of Commonwealth versus Epps, which talks about our touchstone is to do justice. And that requires us to order a new trial where there's a substantial risk of miscarriage of justice because the defendant was deprived of a substantial defense regardless of whether the source of the deprivation is counsel's performance alone. In that case, it was the absence of expert testimony, but that applies equally here. It's not just counsel's performance alone, it's counsel's performance plus the newly discovered evidence, plus potentially prosecutorial misconduct in leading counsel to believe that the prosecutor would do something that he ended up not doing at trial. So one of the problems I have with Judge Agostini's findings is he said, and staying on the issue of Blanchard's bias, he said trial counsel was free to argue and did in closing that Blanchard gave favorable testimony in exchange for not being charged in the home invasion. And that is simply not true. Counsel did not make that argument in closing. Counsel did not mention the Commonwealth's decision not to charge Blanchard in closing. There was no testimony from ADA Giarolo that would support that argument in closing.
Well, I was just looking at the defense counsel's closing argument. I mean, he was clearly let go on a home invasion after this event. Clearly, the victims of that home invasion identified by your reporter. So, of course, he's going to say the lighting was good and all these crazy things. I mean, he does make that argument.
Not really. That's the lighting was good. What is that?
No. He says he was let go on the home invasion after this event.
He mentions the home invasion. There was no evidence, first of all, that the Commonwealth made a decision not to charge him. But he says what does this have to do with the lighting?
No, I get to ask the question.
It's a weak argument. It's a very weak argument.
That has to do with what he said at your client's trial.
Yes.
The lighting, yeah. He's saying, the argument is that he's trying to curry favor with the Commonwealth, so he's saying all this stuff that isn't true. That's what defense counsel argued, isn't that?
That's what defense counsel's theory is. Whether he argued it is another point. He didn't really argue it that well.
He argued something.
With
So, okay,
respect
so
to
Judge
Blanchard.
D'Agostino and I both got that wrong.
So he also found that Rodriguez's admission to shooting the victim doesn't undermine other evidence that my client knew Rodriguez was armed. And again, we return to that phrase, nobody knows it's me. They blame it on KD. That shows that Rodriguez was acting on his own without my client's knowledge.
Why doesn't it just show that Rodriguez doesn't understand the law of joint venture?
I don't see we apply the law of joint venture to this, but Rodriguez simply is saying nobody knows it's me. Nobody knows.
Nobody knows that it's me who was the shooter.
That's right. Had the gun, with a gun.
But what do we do with the fact that your client was the one with the motive?
That's what was argued by the Commonwealth at trial to suggest that my client was a principal in this case. Let's just turn to that really briefly. The judge said that this was clearly presented to the jury as a joint venture theory, and that is not true. It was presented to the jury as my client was the principal. He had the motive,
Does the
he
Commonwealth
had the gun.
have to prove whether it's a joint venture or your client is a joint venture or a principal?
For sufficiency of the evidence purposes, no, but for the weight of the evidence, yes, it makes a difference. When we're looking at the weight of the evidence, tremendous amount of evidence as a principal, scant evidence of a joint venture, that would have made a difference to the jury. If we're just talking about sufficiency of the evidence, Zanetti, then a thimbleful of evidence is usually good enough to surmount that bar. But here
you're saying it would have made a difference to the jury?
Yes.
How so if they're instructed on joint venture?
They're instructed to find him guilty as either a principal, individual, or a joint venture. They were having trouble with the joint venture instruction. They asked for re-instruction on it and got the same instruction that confused them. But they were instructed that they could consider him guilty, they could find him guilty as an individual or as a joint venture. So it's very likely, based on the evidence they were presented, they found him guilty as an individual. He had a gun, he pointed it at the victim, he threatened to start shooting, and then the victim was shot. How is that not a strong argument?
You're arguing
for
that there's a
principal
Morrison
liability?
error in that instruction, right?
Correct.
So
That's
what
my second issue.
is the error?
The Morrison error is the judge said let me quote it correctly.
He says you have to possess the gun, not use it, right? Somebody's got to possess the gun, not use it. The issue, so he should have said somebody has to use the gun? Is that what the problem
Said
is?
not that the defendant used the firearm in the course of the assault. You don't have to find that the defendant used the firearm in the course of the assault.
So if two people kidnap somebody at gunpoint, they both have guns, and only one of them shoots the gun, is the other guy, can he be convicted of armed kidnapping with causing serious bodily injury by a joint venture?
If he knows that that gun was used to commit the crime. The judge was relieving the
Doesn't shoot,
Commonwealth
he can't be liable for the other guy's shooting?
without knowledge of the gun? No, that's what Morrison says.
But Morrison, the issue was that there was no evidence that the gun was used to harm the victim because his bones were, it was only his bones that were found.
I don't believe that's a correct statement of Morrison. Morrison was a joint venture case. In Morrison, one co-venture had a baton, one co-venture had a gun.
No evidence was presented, however, that the gun was used to harm the victim. Investigators were unable to determine the victim's cause of death or if any injuries were inflicted on the soft tissues of the victim's body, as only the victim's bones were recovered.
But here we're pretty sure that Carnevale was shot with a gun.
Twice
We're
in the
pretty
head.
sure, we're very sure that Carnevale was shot with a gun,
So
correct?
what is the knowledge that you're saying is missing here?
The knowledge under the Morrison standard is the jury was relieved of the burden or of the duty to find that the gun, that Neves knew that Rodriguez had the gun that was used to shoot Carnevale. They could have concluded that Neves possessed the gun, shot the gun under Morrison, but they were not, the burden was for them to find, if Rodriguez was the shooter, that Neves knew Rodriguez had the gun, and they weren't instructed accordingly on that.
Okay. Well, I think we'll have to ponder that, and we'll have to leave it at that.
Thank you.
Thank you.
Good morning. May it please the court. Lori Levinson for the Commonwealth. In this case, the motion judge, who was also the trial judge, clearly did not abuse his discretion when he denied the appellant's motion for a new trial based on his allegation that a confluence of three factors combined to create a substantial risk of a miscarriage of justice. Those three factors that the appellant talks about are the lack of admission of the Rodriguez, it's called a hot mic admission because it was recorded in his pocket, the fact that Blanchard changed his testimony in a subsequent trial, and the fact that Blanchard was not charged in this home invasion case. I'd like to start, if I may, with the lack of the admission of the Rodriguez hot mic admission. What's interesting is that the appellant now claims that that was an error sufficient to merit a new trial, but as we brought out, I think 2 days ago when we filed the supplemental appendix, the defendant had filed a motion for relief from prejudicial joinder because of the Rodriguez admission. He did not want that admission at his trial, and yet now he's arguing that the absence of that admission prejudiced him. It did not prejudice
But
him.
why, I mean, assuming that's right, why wouldn't Counsel for Neves want that at trial?
Well, we have a problem with that, Your Honor, and that problem is that in counsel's affidavit in support of his motion for a new trial, he never says why he would or would not have wanted that.
And doesn't that counsel in favor of a hearing?
It doesn't really, because he was clear in his affidavit that, he says that the lack of the admission of that, of Rodriguez's admission prejudiced him. Yet, he was free during the entire trial to have tried to admit it if that's what he wanted to, but he never addressed in his affidavit why he didn't. And
I know you're not defense counsel, maybe you can't answer this question, but do you have a theory why it would be helpful to him not to have that come in?
I don't.
Okay, so let's move on. So it seems to me in your brief, you really downplay the Commonwealth's reliance on Blanchard. But it seems that at trial, the prosecutor really did rely on Blanchard. That Blanchard testified that the defendant aimed a gun at him. The prosecutor said that Blanchard was sure at the time he saw Mr. Neves with a gun. He repeated that he saw two guns and one in the hands of the defendant. Now you're sort of backtracking that. Well, maybe there was only one gun. So,
Well, the fact is, the evidence on Rodriguez's possession of a gun was extremely strong. The evidence on Nieves's possession of a gun was very weak. It was Blanchard, who indeed was a very important witness. But it's interesting, he never actually said he took a gun, I saw a gun was pointed. He said he reached, I saw him remove something from his waistband. It was a
he used the word aimed in it, like he said, and aimed it. I mean, what else do you aim?
I'm just making this up as I stand here, but I mean, you could aim a finger, or you could pretend that you have a gun, and you could aim a finger. There was no really good evidence that.
But I mean, my point is that you're arguing now that it was sort of that attacking Blanchard was not that important because he wasn't really that good of a witness. But at trial, I think the Commonwealth really did rely on Blanchard.
Although you're saying, he was such a good witness, he was impeached on a lot of his testimony during the course of cross-examination. He was impeached on the lighting. He was impeached on the fact that
But that's what your brother's argument is. He could have, that it was important to do, that was their whole defense, and yet they were sort of deprived of really significant ways to impeach him.
But they still went ahead and did impeach him. They impeached him with the fact that just hours after the incident, he told the police that he never saw a gun on Neves, and that was brought out in cross-examination by counsel. He was questioned about his participation in the home invasion case. So he was impeached on a number of different things during this trial. And I think that, as Judge Agostini found in his denial of Nieves's motion for a new trial, that the Blanchard impeachments, the Blanchard inconsistencies, et cetera, didn't really matter because this was a joint venture case. Judge Agostini was always very clear that this was a joint venture case, and therefore the Commonwealth need only prove that there was a gun, and it was very clear that Rodriguez had a gun, and that Neves knew that there was a gun.
I mean, you say he was very clear it was a joint venture case, but in that instruction on kidnapping with armed kidnapping SBI, the judge uses the word individually or as a joint venture. He says individually 7 times. Is that very clear?
Well, he also said or as a joint venture.
Right, but you said it was clear that it was just as a joint venture.
Okay. In the beginning of the judge's instructions on joint venture, which I believe started on page 144 of the March 29th transcript, the judge very clearly said, this is a joint, the defendant has been charged as a joint venturer. And then throughout the remainder of the instructions, he was very careful to always say either individually or as a joint venturer, but he started with the headline that this is a joint venture case. And then just skipping ahead to the Morrison issue, I think that Morrison is really an opposite here because Morrison dealt with what the weapon was, not who the actor was. Here, we know the weapon was the gun. There's no doubt about that. And we know from the jury's verdicts that they believed that there was a gun, and it would seem from their verdict of assault with a dangerous weapon on Blanchard that Neves was found guilty of assaulting Blanchard with a stick, not a firearm, would tend to lead us to believe that the jury did not believe that Neves had a gun, because that assault could have been with a gun if Neves had a gun during this entire melee, yet he didn't. It does appear from the jury's verdict that this was a joint venture conviction, and the joint venture was Rodriguez being the one with the gun, not Neves, which is why the 3 errors complained of by appellant do not prejudice the defendant, because if we look at it as a joint venture conviction, then it doesn't matter whether or not Neves had a gun. It doesn't matter if Blanchard testified at one trial that he believed he saw Neves remove something from his waistband. Never said it was a gun, but we can assume that that's what he meant, but he never did say the word gun. He never described a gun. So it is a bit ambiguous on that front.
I thought the error that was being alleged here, and the error in Morrison, is what does thereby mean? And here, Judge D'Agostini, I pronounced her wrong before, says the crime only requires the defendant individually or by way of a joint venture with Rodriguez and others possessed the firearm, not the defendant used the firearm. But in fact, you have to show that the defendant used the firearm.
Well, not if it was a joint venture.
I mean, that somebody used the firearm.
That somebody, right, and I think that that's what the judge's instruction was, that you don't have to believe that it was the defendant himself. I think if Judge Agostini had put the word himself after defendant, that would have clarified the instruction, but I don't think the instruction rises to a level to create prejudice because of the joint venture, because it's true that they didn't have to prove that the defendant used the gun, just that one of the joint venturers.
That's not how I read that instruction. I read it as the difference between possessing and using, not who used it. But
that's interesting, because that's really how I read it. I read it that the Commonwealth does not have to prove beyond a reasonable doubt that it was the defendant himself who used the firearm. They just have to prove that he knew that a firearm was involved, and clearly a firearm was involved.
I guess the question is, what would a jury hear in the context of the whole instruction? Is there anything else in the whole instruction that would help the jury on that?
I think Judge Agostini's constant highlighting and coming back to joint venture, individually or joint venture, and particularly his highlight at the beginning of the beginning of the charge on all of the substantive crimes. He was very clear, I want you to know that this case has been charged as a joint venture case. And then, of course, he goes on, as he must, to give the jury the opportunity to find either principal or accomplice liability.
And he definitely instructed that that there had to be knowledge that the other actor possessed a gun.
That would have to be part of the instruction, and right now I'm not remembering exactly if Judge Agostini said that he had to have knowledge.
That's what Justice Grant was just showing me on page 148 of the transcript.
Okay, 148.
If the use or possession of a weapon is an element of the offense that is charged, the Commonwealth must prove that the defendant armed himself or that he knew another person was armed at the time that the crime was committed.
And in this case, of course, we argue that the defendant knew that Rodriguez was armed, because it seemed pretty clear that most people at that party knew that Rodriguez was armed, and he was down there, and it was, again, part of this whole melee at the truck, come out or we'll start shooting. Some witnesses said it was Neves who said that. Some witnesses said they weren't sure who said that. I do think it was Blanchard who testified that it was Neves who said that. If there are no other questions, I'd be happy to rest on my brief.
Seeing none? Thank you. Thank you both.
Okay, thank you.
Very, very interesting, tough case. Case is submitted.
Thank you.
All right. Third case is Commonwealth versus Castro, 23P91, and we'll be hearing this case and one more before our break. So we'll be here. We'll have to take a. We're going to hear third case and the fourth case, and then we'll take a recess. So. This is Edwin Castro.
Good morning, and may it please the court, Aaron Opperman on behalf of Edwin Castro. I am here today asking the court to overturn the defendant's conviction, and there are three issues raised in his brief. The first issue deals with admission of GPS evidence, and two arguments are made with respect to that ruling, both alleging that the court abused its discretion in admitting that evidence at trial. First, that it wasn't proved to be sufficiently reliable in this particular case, namely because of the issue of the inclusion zone and Mr. Kalgani's testimony, Kalkangni.
But you agree that it's generally reliable?
Of course, I agree that it's generally reliable. In this specific case, the argument is that it wasn't sufficiently reliable because of the testimony that due to the inclusion zone, the frequency with which the measurements were exported or recorded varied. That coupled with the fact that about a third of the measurements presented to the jury had quite large margins of error, and in addition to the fact that these houses were essentially across the street from each other, that in this case, on these facts, that the way the GPS was used and the fact that it was, the measurements were recorded at varying frequencies, that it was not sufficiently reliable.
But where there's so many data points, why wasn't the judge correct in ruling that the fact that some had greater margins of error goes to the weight, not to the admissibility?
I think it's a threshold matter, and I do think that this specific case was certainly at a minimum very close to that threshold. I don't deny that generally GPS technology is and has proved to be for some time quite reliable. The argument is simply that in this case that threshold was not met due to these other factors. In addition to the reliability issue, kind of the gatekeeper issue, the court abused its discretion by admitting the evidence due to the fact that with approximately a third of the data points being such large margins of error, a number of them being a longer distance than the victim's house and the defendant's house, that the probative value was simply not outweighed by the prejudicial value. That prejudice outweighed the probative value of the evidence.
So what's the prejudice?
The prejudice is that it wasn't reliable, that it was admitted, that it appeared to be strong evidence of GPS points placing the defendant at the victim's house, but because of the unreliability due to the large number of data points having such a large margin of error, that the reliability did not outweigh the prejudicial nature of admitting GPS evidence.
But what's the prejudice?
The prejudice is that unreliable evidence was admitted against the defendant, and that it was evidence that appeared on its face to be very strong of guilt.
I mean, it seems like that argument goes more to the probative value. You're saying it has, you know, weighing prejudice and probative value, that not much probative value because there's so much error.
Correct, and that the prejudice of admitting evidence of a GPS nature, which I think was likely concluded by the jury to be very strong evidence of guilt in relation to the other evidence at trial, that this admission of this evidence would have made a difference in the jury's decision.
Maybe you should talk about the other evidence and why this was you're saying sort of the lynch point.
Certainly, and obviously the other evidence, I would say the only other piece of evidence was the DNA evidence, and there was substantial testimony about the ease with which DNA is transferred from one location to another, how close the defendant and the victim lived together, how much she traveled in the area, the assumption that the defendant did the same, and that DNA was obviously it was the defendant's position that the DNA was transferred in some other manner than him being in her house. So I would argue that the GPS evidence was the strongest evidence at trial, and that it would have made a difference in the jury's mind. Moving on from that argument, I would touch on the admission of testimony that the defendant was on a GPS and subject to home confinement. Not challenging the admission of the fact that he was on a GPS bracelet, at least in the context of this argument, but the fact that he was on home confinement. It was completely irrelevant at trial. It wasn't even relevant to the GPS evidence. There was no need to testify that he had an inclusion zone. I think that was testified.
Why wasn't it relevant to show that his DNA would not likely be on the victim's sleeve another way?
I don't think it was relevant to the extent that it would have outweighed the prejudicial nature, because there was no concomitant testimony regarding how long he had been on a GPS bracelet. There was testimony about, I believe there was testimony that DNA evidence is a type of forensic evidence that is long-lasting.
So if evidence of the home inclusion zone had not been admitted, couldn't defense counsel have gotten up in closing and said, ladies and gentlemen of the jury, they want you to believe that my client is going to break into a house right across the street and sexually assault a woman who lives there? That's ridiculous. Isn't the probative value of the home inclusion zone to explain why he picked that house?
I think that is what was argued by the prosecutor. It wasn't argued that it was probative of that fact due to that line of reasoning. And if it had been, what I think defense counsel might have and should have said was, I will not argue that fact, sort of an opening the door situation. Because I don't disagree that if defendant had made such an argument, the home confinement fact would have been relevant to rebut that. But defense counsel didn't make that argument and didn't allude that he was going to make that argument. What the prosecutor used this fact for was to kind of bolster their speculation that this was his plan, motive, and his only opportunity. The court then took that speculation and used it as kind of a building block to reach the conclusion that he did on the issue. But I think that absent any indication that defense counsel was going to make that argument, which I agree, if the evidence of home confinement was admitted, that argument would have been improper. I think it was more prejudicial than it was probative as the case was presented to the jury.
Can you explain on this issue, on page 22 of your brief, you say, in essence, the Commonwealth argued that the fact of home confinement was bad act evidence relevant to opportunity, intent, preparation. The problem with that is that for the evidence to be relevant, the court was required to assume the guilt of the defendant. Could you explain that? I don't really follow.
Yeah, so I think in deciding this issue, the court kind of worked backwards. The court assumed that it was the defendant who committed this crime, and therefore worked backwards to speculate on what his plan was, what his motive was, or what his opportunities were, and concluded that because he must have committed this crime, he did so and he created this plan, he had this motive because of his home confinement. So it's more of I I think the court kind of worked backwards in reaching its decision rather than taking something that was, and I'll give an example. If there was evidence that the defendant had been seen in a car outside the home scoping out the home, that would have been a building block to reach the conclusion that that was evidence of motive, plan, preparation, et cetera. However, taking the fact that he was on home confinement, speculating about his mental state due to his status on home confinement, and assuming that, well, he was on home confinement, he must have had this plan to stay within the inclusion zone, that's not the line of reasoning that a court should engage in determining that the evidence is probative enough to admit it at trial. I'm not sure if that answers the question.
No, I mean, I think it does.
The last argument, and with the closing argument, I do just want to focus on the prosecutor's statement to the jury, or argument to the jury. Do you think it's an accident he chose a victim who lived in that house, a house with fellow Salvadorians, that it inferred that the defendant sought someone out of his, either of his own ethnicity or that he chose someone because of their specific ethnicity or national origin, and that was improper enough, particularly coupled with the other.
I mean, in your reply brief, you argue that it's evidence of a hate crime. I think that's a little far-fetched. I think
I'm sorry, I didn't hear you.
You argue that it's evidence of a hate crime, that it could be taken as evidence of a hate crime. When I think it's the context is that he's picking somebody nearby, where he's likely to fit in.
Yeah, I mean, I use that phrase, I think, inclusive of, or as a phrase that can be used in a legal sense to describe any crime against someone specifically because of their ethnicity or national origin or race, et cetera.
Yeah, I mean, but that's not what the prosecutor is implying.
Okay, yeah, and I don't need to argue that it is. It was illustrative only that the prosecutor pointed out or introduced the subject of national origin and ethnicity when there was no evidence that was a factor in this case.
But the victim testified she was born in El Salvador and that she recognized the defendant's accent as being either Honduran or Salvadoran.
Right, and I do think that was relevant to the issue of identification. It wasn't challenged at trial, nor is it challenged on appeal, but alluding to the fact in closing that the defendant may have sought someone out specifically because of their national origin or ethnicity.
Could the prosecutor have argued that the defendant picked somebody who would have spoken Spanish since he spoke to her exclusively in Spanish?
I don't think that he could have. I think that the argument, if he had made an argument, particularly in light of the home confinement evidence being admitted at trial, that he sought someone out for their location, that would have been fine. But without any evidence that he sought someone out because of some immutable trait about them, I think that was improper. And I think
it was improper because it was not a fair inference?
Because it was not a fair inference in light of the high risk of prejudice. I think that it's not too far-fetched to conclude that there are stereotypes about Salvadorians in particular, with information in the news about prisons in El Salvador, Salvadorian gangs, et cetera, that's simply a topic that should not have been introduced into trial in this particular context. That race
But the prosecutor was talking about the victim's ethnicity.
Correct. Well, I'm sorry, I forget. They were talking about her ethnicity relative to his ethnicity. So it wasn't just her ethnicity, it was a quote-unquote fellow Salvadorian. So it was introduced in a way that reads that he was preying on someone that might have been particularly vulnerable because of her ethnicity and national origin.
Would your argument be any different if he was white and the prosecutor, and she was still Salvadoran and said she was Salvadoran?
It might be a little different in the sense that the argument would touch on the victim's status, but not necessarily traits about the defendant. I would probably still be making the argument, but I think in this case, the way it was made, it not only touches on what unique vulnerabilities the victim might have had, but also some potentially unique or specific traits to the defendant.
Could the jury take notice of the likelihood that somebody of Salvadoran ethnicity might be less likely to call the police?
No, I do not think they could have. I think if there was expert testimony about that, statistical analysis on that issue, then they could. But no, I don't think that would be a fair inference just based on the ethnicity and national origin of someone. And if there are no more questions, I will rest on my brief for the case.
Okay. Thank you very much.
Thank you.
If you want to refresh your recollection on who the prosecutor was, I think just look to your right. I'm just guessing.
Good morning, and may it please the court, 88 Charles Marshall on behalf of the Commonwealth, joined by, as Justice Massing just pointed out, the trial prosecutor in this matter, ADA Ian Palmbaum, asking this court to affirm the defendant's convictions. Addressing first the defendant's claims as they relate to the GPS evidence, beginning with the data itself. So I'll remind the court, as it surely knows, that this is an abuse of discretion standard, and this court need not look any further than Commonwealth v. Davis, which is directly controlling and which was the case relied on by the trial judge, acting as the initial gatekeeper of the reliability and thus the admissibility of the GPS here. The argument by the defendant here, like in Davis, is one of weight and not admissibility, thus dictates the same result. He has done really nothing to differentiate the underlying facts or the circumstances of this case from Davis. In fact, I would suggest that the distinguishing factor from here in Davis is that there was actually more presented to the court here than there was in Davis. Much like in Davis, the same preliminary baseline testing that the court relied on to find reliability there was done here. However, there was also additional testing. There was testimony from the witness during voir dire about the alpha testing, which was the same testing as described in Davis. There was also beta testing, which was distributing it out to the actual consumers, the probation departments who were using their specific devices so that they could test them themselves, and he testified that that was done on this specific device. Further, the witness took the steps, and this was after the GPS data was compiled for the investigation, but took the steps to look and see if there were any prior malfunctions with that specific device of the defendants, whether there had been any repair issues or repair requests, and confirmed that there hadn't been. In addition to that, he gave the traditional testimony in terms of how GPS works in general. He described that the satellites that are used by their devices are the same satellites used by phone carriers, by people every single day on their smartphones, that those satellites were put up into the orbit by the United States government and the Department of Defense, that they were maintained by the Air National Guard. All of that testimony in voir dire sufficed to give the judge adequate means, essentially, to find that it was reliable, to admit, in accordance with the case law that existed as well. And in fact, Davis states that a judge could potentially, in the realm of GPS data, be fine making a finding of reliability and admitting that data even without an extensive voir dire, just based on prior precedent in court, and there had been prior precedent here. Thistle was a main court or a main decision in the SJC that Davis relied on. And so where the judge specifically cited Davis, went through an extensive voir dire, I don't think that we can find an abuse of discretion in allowing data that has been deemed inherently reliable by our courts, and thus it satisfies both the Fry test and the Daubert-Lanigan test. Moving separately to
Can I just ask you I'm just looking at the charts here. The big green circle, that's the, what is that?
That represents the inclusion zone.
Okay, and the dot that turns green and yellow and red, that represents the defendant?
That's the device attached to the defendant, yes.
Right. And how does that work in with the chart, which is on the very first thing on page? It's a RA. It's not a picture. It's a chart. It says it's Record Appendix 36, a 10T GPS data report.
I believe I have it in front of me.
Okay. How do you read them together?
So, you're referring to essentially 6A, the spreadsheet?
Yes.
Your Honor? Okay. So That's the raw data. The charting is just the charting of that raw data.
It's, so the yellow dots, or whatever color they are plotting the latitude and longitude of each of those data points.
That's correct. Essentially, the mapping contains the same hard evidence and data as the spreadsheet itself, Exhibit 6A. However, where we can't really expect the juror to have an intimate knowledge of these longitude and latitudes and where they are, it's only so useful as it is provided with a chart to depict essentially the relevant area and where it's going itself. And while counsel does rely, and the defendant relies on essentially the large margins of error, that was akin to the argument made in Davis, and they said that that is weight. And as you said, Grant, I think it is especially relevant that there was such a mass of data produced with varying degrees of error and degrees of feet that the jury themselves could look at and make their own determinations of that weight. So while, yes, there are some outliers, including one specifically highlighted in the defendant's brief, there's also one highlighted in my brief that I believe puts him in the house at about 702 with a error rate of about 26 feet and indicates that it was based on a connection to 9 satellites, whereas the data only needs 3 to 4 to make a reliable finding of a point. So there are certainly points that are very strongly suggestive and reliable to suggest that he was in that house at the time of the crime and sometime there before and after. Turning separately to the evidence as to the fact that he was on a home confinement condition, that did have independent probative value from the GPS data itself. One being one that wasn't mentioned by the court, and I'd be remiss if I didn't, identification. It helped bolster the identification. And where identification was the crucial issue at trial, this was a circumstantial ID case, the attacker was not apprehended on the scene. When it's the crucial issue at trial, that weighs in favor of admission. And its independent value to the identification was that there was strong evidence that this attacker had an intimate knowledge of the residents, not just who lived there, where they lived, but also their morning routines based on the timing of the attack and the ruse by which he gained entry to specifically the victim's apartment. He chose to essentially enact his plan after everyone in the victim's apartment had left for the morning and many people in the upstairs apartments had left as well, giving him the best chance to succeed. And in trying to gain entry, he knocked on the door and stated, "It's the man upstairs," seemingly referencing the landlord's son who lived on the 3rd floor, suggesting that not only did he know the right time to attack, he knew what he had to say to get into that house. And obviously, that is incredibly relevant to bolster the identification. It also had independent value aside from just identification, that being the motive, opportunity, plan, based on the proximity to those 2 houses and the fact that not just he lived there, but he was confined there day in and day out, not going back and forth, but had ample and almost inescapable opportunity to watch that house and learn these details that would then aid him in his attempt to get into the house. It's also incredibly relevant. Also, Justice Grant, and this wasn't a point that I made in my brief, honestly, because I didn't think of it, so kudos to you, but it was also relevant for dismissing the DNA argument, that this was an innocent transfer on the bus or on the train or going to and from work. He can't leave the house. He had been put on that home confinement, I believe, August 1st, so more than 2 months prior to this event. There is no scenario where he is essentially adhering to that home confinement and also would have been able to transfer the DNA. So it did have independent value itself, and the probative nature, whether we analyze it under a 403 standard or a 404 prior by act, and I don't think there is much to suggest that it should be analyzed under 404, but in any event, the probative nature of both the data itself and that home confinement condition, independent of the data, was extremely probative to the crucial issue in this case, which was identification, and suggesting that he himself was the one that committed this crime. Moving lastly to the closing argument claims. So there was no objection to any portion of the closing argument, either during the prosecutor's closing argument or after it. So that does mean that this court reviews it on a substantial risk of a miscarriage of justice. And I don't intend to dwell long on the closing, the arguments made about the prosecutor's closing, other than to suggest and argue to this court that it was well within the permissible bounds of advocacy. But I do want to touch just on the nationality point, because I know this court focused on that, and that's what counsel focused on. So I would suggest that the defendant mischaracterizes not only the prosecutor's statements as they were given, but also wholly ignores them in the meaning and context of the entire case. So in testimony, it was elicited from both the victim and the defendant that each of them were from, or elicited from the victim that she was from El Salvador, and then elicited from a booking officer who had dealt, or an officer who had dealt with the defendant prior, that he and his listed origin was from El Salvador as well. The victim then testified that during the course of the attack, that she recognized the defendant's accent as either Honduran or El Salvadorian, and those facts, when viewed in conjunction, again, helped to strengthen the proof that it was the defendant who committed the crime, going back to the crucial issue of the case, that being identification. And the victim's national origin of from El Salvador was helpful in allowing the jury to assess her credibility and give weight to the fact that she recognized that accent.
But your sister, she doesn't dispute that. It was the statement about attributing his motive in choosing that person.
And that statement, when isolated and viewed entirely out of context from the rest of the closing in the case, I understand why it could look like that just on its own. I mean, the statement is essentially, do you think it's an accident that he chose a victim who lived in that house 52 feet away, comma, and I do think that comma is important, a house with fellow Salvadorians. I read that, especially in the context of the closing and the rest of the case, the prosecutor's making two separate arguments. He's making the motive argument based on why he chose that house 152 feet away, having to do more with the home confinement condition, and then a house with fellow Salvadorians. He's making the point that I have made and that some of the judges have made, that the fact of their national origins was relevant to the identification, and them being able to speak to each other in Spanish, recognize accents, and more strongly bolster the actual identification. And the case law is clear that we don't analyze statements in closing argument on their own. We do it in the context of not just the closing, but the case itself. And it's clear that the value of both their national origins was to explain her recognizing the accent and then connecting the person who committed the crime to the defendant and bolstering that ID.
So there's no theory then that choosing somebody who's a fellow Salvadorian American would make it easier to commit the crime?
I can't think of one, Your Honor. I mean, the case that's relied on in the defendant's brief is this Graziano case, the Godfather case, that dealt with a situation where a prosecutor in closing did make use of national origin, essentially an attempt, there they found, to appeal to the prejudices based on national origin and thus sweep the jurors beyond a fair and calm consideration of the evidence. Essentially, the prosecutor there was trying and prosecuting an Italian-American defendant and referencing The Godfather and drawing on those prejudices from those movies about Italians and organized crime. That is not what happened here. The origin of these two parties, the defendant and the victim, was relevant to the identification and cut to the core of the case. When put in the context of the closing and the rest of the case, that's clear and would have been clear to the jury. And aside from that, on both issues, there's no argument that there was an error in instruction. There were contemporaneous instructions on the uses of the GPS in the home confinement. Again, in closing or final instructions, there was the typical instructions we see from the judge about the roles of both parties as advocates, about the usage of openings and closings, how they're not evidence. And so it's hard to imagine, in the context of the case and the context of the instructions, that we were at any risk of the jury being swept up in some sort of prejudice based on those national origins. And I will just finally say on the last point, because I'd be somewhat remiss if I didn't point it out to the court, this is the outliers argument. So the quote about the outliers from the GPS as it appears in the defendant's brief is, "Throw out the outliers," and that's the quote. The actual line from the prosecutor in argument himself was, "Here is an outlier, 607 feet. You can disregard that one if you want." So he was not ordering them to ignore these outliers. He was simply, and factually correct, pointing out an outlier. I think the next closest point in feet to that one was something like almost like 400 feet. I think it was 388 feet. So it was, in fact, an outlier. and also where the prosecutor himself qualified that it was ultimately up to the jury to decide whether or not they actually wanted to disregard that or use it, that was well within the bounds of permissible argument as well. And unless, I see my time running out, unless there are other questions, I'll rest on my brief.
Nope, seeing none, again, thank you both. The case is submitted. So we've heard the 3 criminal cases today, all well argued, so you set a high bar for the civil lawyers who are coming up next. We're going to hear one more case and then take a break. So the 4th case is named party Linhares versus Dennis Planning Board, 25P594. I can pronounce Costa. That's an easier one to pronounce.
So good morning, and may it please the court. My name is Peter Farber, and I represent the appellant, Janice Costa. Ms. Costa is a single woman, lives at 32 Alexander Drive in Dennis. This is her principal residence and has been for the last 30 years. She's appealing the decision of the planning board of the town of Dennis, which in this matter was acting as a special permit granting authority. There are 3 issues in the case, and I think they're very clearly set forth in the briefs of both parties, and I will address them in the order presented. The first, of course, is jurisdictional, and that is whether Ms. Costa has standing to appeal the decision of the planning board and then continuing to appeal the decision of the Superior Court. In this case, in my own opinion, I think standing is clearly established. Ms. Costa's lot abuts the property that is proposed to be developed on 2 sides, and all of the traffic that would be generated from this project will go directly by the side of her home, and that is not a de minimis amount.
What is there now? Is there a house there, or is there just an empty lot there now?
I'm sorry, Your Honor.
Next door to her home, where the road is going to be, what is there now? Is there a house there, or is there nothing there?
No, on the adjoining lot, Lot 8, that is now owned by the developer. That there is a house very similar to Ms. Costa's. All these houses in the neighborhood are very modest ranch houses, built in 1969.
She's gonna. Facially, it seems like it's a big difference to live next door to a house than to live next door to a street with 271 trips per day.
Right.
Can you? And that's the asserted injury, right? Is the trips, is the traffic.
The traffic is the basis of her statement.
So what part of the bylaw speaks to trips and traffic what interest does the bylaw protect?
The entire bylaw, I can't answer that question. Section 4.9 is the section that addresses affordable housing developments in the town of Dennis, and that bylaw, I have a copy of the decision right here. It's in Appendix 1 at page 66. Is the town planner, again, we allege that the town planner wrote this decision, presented it to the planning board on the night of December 3rd, and it was approved.
I want to get to that, but you raised it up. You allege that the town planner, do you have evidence of that?
Well,
the town planner wrote it beforehand and then it was just rubber stamped?
I think this is not disputed, first of all, but that the board voted that night on a decision that is probably 10, 15 pages long. And clearly, and actually, the minutes of the meeting, in my reply brief, I made the mistake of saying that they were not included, or implied they were not included in the record, but indeed they are. And the motion to approve is at page 63 of volume 1 of the appendix. And I can read that. It says, Miss Farmer, she was one of the members, made a motion to approve the special permit for 24 new 2-bedroom homes with 25% deed restricted affordable to include 19 conditions and based upon the findings provided in the staff report. And the vote then is 5 to 1 to 1. And the members who opposed or abstained are mentioned, but the others are not. And so it was simply an up or down vote. It was there were no specific findings made by the planning board or any of the members.
Okay, so I'm sorry, we're back to my original question. What interest in the bylaw where does the bylaw talk about traffic?
About traffic?
Yeah.
Well, okay, going back to...
Or if you can point to me to one of the factors here.
Okay, so the bylaw itself, it doesn't mention traffic per se. It's the effect on the neighborhood, whether the development, density increase, or relaxation of zoning standards has a material detrimental effect on the character of the neighborhood. That's one of the findings that the town meeting has directed the planning board, the special permit granting authority, to make. And it's our position in this lawsuit is that the findings that were required under that section, that factor, are wholly inadequate because they do not address what I'll call the 800-pound gorilla in the room, and that is that all of the traffic from the proposed development will enter and exit through a lot that is 75 feet wide and adjoins Ms. Costa's home. And there's not a statement, not a finding, no discussion in the board's minutes or in the decision that addresses that. The closest the board gets is, of course, the board is not writing this, it's the town planner. On page 68 of the volume 1 of the appendix, there's a paragraph number 16. The construction of the 24 new units of housing as conditioned would not create a nuisance, hazard, or congestion, nor would it cause other significant harm to the neighborhood. That's a very generalized finding, and it doesn't mention the fact that the proposed development will result in 271 vehicle trips every day of the year through an established neighborhood, or certainly 2 lots that border the entrance. The other finding, or proposed finding, number 19, traffic generated by the residential use of the property will not create congestion or safety issues along Alexander Road. So those are the 2 as close as the board got to making any findings, but there's no discussion in the record of the meeting that they even addressed traffic. They just adopted the town planner's, what he had written in the proposed decision.
So we have a trial on the merits that include, we have a trial on standing, but at that trial, this traffic expert is introduced and testifies about the number of trips, and the judge finds that that's pretty much in agreement with the board. I mean, even if you do have standing, couldn't the judge use that same evidence to say that the board there's no error here, there really wasn't significant?
Well, I think if we move past standing, I mean, I cited in my reply brief the case I found, Perez versus the Board of Appeals of Norwood, page 11 in the reply brief. And that's a case that's somewhat similar, where a proposed new driveway to a small development in that case is going right by the side of an established residential property. This court found in 2002 that that change and the additional traffic generated by what looks to be 5 or 6 house lots was sufficient to confer standing on the abutter. And of course, there's many cases, other cases cited in the brief as to what the traffic is a protected interest. The second issue, if I may go on, is the question about whether the Ms. Costa's, well, it was actually at the time, there were other plaintiffs still in the case. They dropped out when the sewage disposal system was that issue was finally settled. But in early May 8th of 2024, that was when we served a motion to amend the complaint and to add the additional language, the additional complaint to issues relative to the decision itself being defective for lack of adequate findings and the reasons.
So tell me, I wasn't clear from your brief what you thought what you wanted to add and that we weren't allowed to add. But so lack of adequate findings, that's one of them. What were you not allowed to bring up because of you weren't allowed to amend the claim?
What were we going to bring up in a second amended complaint? Well, we were going to, up to that point, and I agree with my brother, the substance of this complaint, the zoning appeal, was the fact that the Board of Health had never made the requisite findings, all right? And as we approached the trial in 2024, the developer provided an alternative system, one that did meet the requirements. So that issue subsided, although there was still an issue as to whether the board had approved the original decision. But then we wanted to highlight that there's another issue in this case, and that has to do with the legality of the decision itself. Are there adequate findings to meet the standards that the town directed the board to make? And that's what we raised. Judge, as I stand here today, I would say that an amended complaint was probably not even necessary. And I say that, and I think Judge Gilday recognized that since the burden of proof and the burden of persuasion is always on the developer and...
I'm sorry to interrupt that. Time is short. So one of the issues that you wanted to highlight was the legality of the decision. What else?
What else is there?
Yeah.
The third issue. I'll go to the third issue.
No. By not being allowed to amend the complaint, what else were you prevented from arguing? You're saying illegality of the decision. What else?
I'm sorry, Judge. I have my hearing aids in.
I'm sorry. What issues? So you say it was prejudicial error not to allow you to have the second amended complaint. And I just want to know what were you precluded from arguing? And so one of them you're saying is the lack of the legality of the decision. Anything else?
No, the third issue, again, correct me if I'm off base here, but if your question is directed to what I consider the third issue, and that looks to the actual decision itself, I think the judge misinterpreted the law, and I've cited some comments that he made in his decision. He kept saying, this is a new trial, this is a de novo. I don't have to look at the decision of the board, and whether that was in any way defective, I can cure it because we're here today for a de novo trial. But all the cases I've cited over the last literally 100 years, starting with the Bradley case, and then the Prusa case, which are cited in my brief, all of them say it's a two-pronged. On an appeal of a zoning board decision, you first look at the actual decision of the board. If that does not pass muster, that's the end of it. The judge cannot provide findings that substitute for what the board did not find. And that's the case, that's our argument on the third issue, that the very generalized statement, there's no harm to the neighborhood, absolutely obscures what is standing at and facing every one of us. 217 vehicles are passing next to a home that there's been zero traffic for the last 59 years or so, since 1969. And the board made not a single finding on that issue. And that is the biggest issue in the case. So we're saying that the board missed the boat on that one, and the judge could not affirm the decision of the board when such an important finding is missing. And you can't just say there's not going to be, how was it put in here, nuisance, or there's not going to be congestion in the road, because the traffic study actually was looking at the ends of the road. And this is a very minor road.
I read your brief as saying that your argument was that there are three special considerations in 4.19, and we don't have a vote on each of the three.
And that's the other thing, Your Honor. Again, if you look back, I cited the Wendy's versus old-fashioned hamburgers case, but there's many that precede that. And all of the statutes from 1933, 1954, 1975, all say the vote of each member on each criteria must be part of the decision. And that's the way you can counteract any kind of a generalized finding, which is what occurred here. And, you know, as I said in my brief, when the statute is clear and says something that clear, with such clarity, and that is the vote of each member on each criteria is required, this decision did not pass muster. So I think my time is up, or probably passed. Thank you, Your Honor.
Okay, thank you.
Good morning, Justices Singh, Massing, and Grant. My name is Michael Pierce. I represent the appellee, the trust defendant in this case, Catherine McGregor and Molly McGregor, as trustees of the Cape Commerce Nominee Trust. We're here today, Your Honors, to ask that this appeals court affirm the trial court's decision as it related to denying, dismissing Ms. Costa's case due to lack of standing. We'd ask that you affirm that the trial court correctly determined that Ms. Costa did not have the ability to file a second amended complaint. And we ask this court find that the trial court correctly found that the board gave full credit to the relevant bylaw factors. Starting on the first issue of standing, there's no dispute in this case that Ms. Costa is an abutter to this project and that there's an automatic presumption that she's an aggrieved party. When that occurs, the defendant is able to rebut that presumption by showing that as a matter of law, the claims of aggrievement are not those intended to be protected by the Zoning Act, or the defendant can rebut that presumption by offering evidence that is a finding contrary to that presumed fact. In this case, the only expert was presented by the trust, a traffic engineer, Matthew Keeley, who testified that the location of this property on Alexander Drive was a pre-existing lower traffic area, and that the additional traffic caused by this project is going to be a de minimis effect. Specifically, he testified that during the peak hours of commuting in the morning and in the evening, the traffic would increase approximately one extra car for every 2 to 3 minutes during those two time frames. For other hours of the day, Mr. Keeley testified that it would be less than one additional car visit for 2 to 3 minutes.
Okay, just to eliminate one of the questions I had, you said there were two methods of rebutting, or three, and that this is the last one, showing that the evidence doesn't, that you're not saying that this isn't an interest that's protected by the bylaws. You're saying that it's de minimis, that it's not a factual, it's not a factual problem with traffic, right?
I'm saying that the trust has effectively rebutted the presumption of any sort of aggrievement or injury related to the increase in traffic, especially in light that Ms. Costa did not present any testimony, whether herself or through her own expert, to rebut the evidence of Mr. Keeley. Besides her personal opinion or speculation, which is not permissible for her to rebut based upon the evidence presented at trial by the trust. So we'd ask this court to affirm the trial court's decision that Ms. Costa did not possess the standing to appeal the special permit granted to the trust in this case.
So your argument is that because there's only going to be there's only be a car every 2 or 3 minutes, so that's 20 or 30 cars each hour during the peak, and a total of 271 trips a day, that satisfies your burden of putting out, that shows there's a de minimis harm. Now she's got to show that it's more than that?
That's our position, Your Honor. And the trial court found that any implication otherwise that the traffic would increase or inflict a harm on her would be just rank speculation. This zoning standing law is not particularly easy to grasp. And so tell me why, if my house suddenly got moved from an area where I'm on a unbusy rural street to an intersection with 200, right now there's 0 trips coming by her neighbor's house, but now it's going to be 271 a day. Why is that de minimis? Well, we felt like during those, it was already a pre-existing low traffic area at that site, Your Honor, and I agree, it is going to increase, but the testimony at trial through an uncontested expert was that increase of 1 additional vehicle per 2 to 3 minutes for the 2-hour period in the morning from 8 to 10 or from 5 to 7 was going to be a de minimis impact, and the court found that testimony to be credible. And again, there was no testimony by Ms. Costa in this case to say otherwise.
Well, it sounds like you have the factual evidence, but characterizing it as de minimis is not the same thing as a. That sounds like that's something that could be challenged. The facts are the facts, whatever was presented by the expert, but then the characterization is something else, and doesn't she have the ability to say this is not de minimis?
She could, Your Honor, but Ms. Costa did not testify or did not present any evidence whatsoever to show that there would be more than a de minimis impact. In fact, the trust is implementing additional buffer factors in terms of a stockade fence, a berm, and additional vegetation to kind of further reduce any sort of increased traffic effect that's going to have at that intersection. Moving on to issue number 2 is whether the trial court correctly exercised its discretion in denying Ms. Costa's motion to amend motion to amend her complaint to be the second amended complaint. And the trial judge went through the detailed, lengthy history of this case over 5.5 years with multiple times that this case had been scheduled for trial and continued, and found that at such a late time, interjecting 3 entirely new issues into this case 14 days before the scheduled pretrial conference.
What were the 3 entirely new issues?
Well, one, Your Honor, I believe had to do with an easement issue, whether this was a private easement or an easement appurtenant issue, that I would say was not an interest intended, not an interest that this statute was intended to protect. I think the third issue, again, had to do with the wastewater issue, which had been the crux and primary challenge of this case for 5 years. The case was remanded back down to the Board of Health to rectify and
I'm really just trying to figure out what the amendment was about. So you said there are 3 issues: the easement, something about wastewater, and what was the third one?
And I believe setback, Your Honor.
Setback.
It's significant that the easement issue is currently pending in Barnstable Superior Court. Ms. Costa has filed a sister action specifically on that issue of whether there's a private easement that exists in this case. That right is preserved to her and been pending for a pretrial conference in the fall of this year. But the trial court correctly found that...
And there's no claim in that case of prior pending litigation raising the same claim?
Yes, I mean, there will be ultimately. We hope that depending on the outcome here, that case may shift. But
So then that doesn't really help her if you're going to be able to say that, well, we had it. Well, she could have raised it here in 2018, but she didn't.
She didn't, but she quickly, when the wastewater issue was resolved, which was the main issue in this case for 5 years, Ms. Costa, in a further attempt, in my opinion, to delay, install, and beat this project to the ground, interjected 3 new issues. One of them being she filed an action in Superior Court on that easement issue. But the trial court did not abuse its discretion in finding that there was simply undue delay and prejudice to have these 3 amendments come in at such a late hour, 2 weeks before the initially scheduled June 2024 trial. I submit that the trial court correctly denied that request and appropriately exercised its discretion.
Notwithstanding all that, you actually do get into the easement thing a little bit in your brief.
Yeah, I do, a little bit, Your Honor, but I'd submit that...
As does...
that the easement issue isn't a legally recognized injury that the zoning statute was intended to protect in this case. We do lightly touch on that in our brief. And that issue will apparently get litigated in the pending Barnstable Superior Court case on that issue. The third issue, Your Honor, speaks to whether...
So then that, you're saying here that the easement issue is not an issue that can be brought in a zoning challenge?
That's my argument, Your Honor.
That's gonna harm your res judicata thing in the other case, but, okay.
Perhaps. The third issue, Your Honor, is whether the trial court correctly found that the board's decision was legally sufficient, where the decision reflected that the board followed the bylaws directives to consider the 3 factors. 4.911 of the bylaws, Your Honor, states that the board can or shall consider 3 relevant factors. I can just briefly summarize those: that the applicant has conformed to the design standard of this bylaw and will need to deliver the affordable units, whether the proposed development site plan is designed in its site location, proportions, orientation, materials, landscaping, and other features to feature a stable and desirable character, complementary to the site's natural resources and features, and whether the development density increase or relaxation of zoning standards has a detrimental effect on the character of the neighborhood or town and is consistent with the performance standards of the Dennis zoning bylaw. I submit that the trial judge and the board gave full consideration to these 3 factors. The trial court was very specific in its order outlining the evidence at trial that supported the board's findings, that they considered these 3 factors. The board considered the special permit on the trust, providing deed-restricted affordable housing. The board found that the project is going to be properly screened from abutters. The board found there's going to be appropriate green buffering between the 24 homes and adjacent residences. There's going to be adequate parking, adequate lighting. It's not going to create any undue...
What's your response to Mr. Farber's argument that these findings here were pre-written by the town planner and not really representing what the board did?
Yeah, I think that the trial court touched on that in its findings of fact, Your Honor, and I don't think there's anything that prohibits the town planner or from the board from asking the town planner to do that. The trial court specifically ruled that there is no prohibition upon the planning board in seeking to have a draft prepared by a professional employed by the town. The public vote and decision itself signify the planning board members' findings and decision. So I'd find like there's nothing prohibiting the town planner from doing just that. But the trial court's order was very specific, going through the evidence. Again, the uncontroverted evidence at trial. There was no testimony by Ms. Costa or any other witness on her behalf. And the trial court gave a very, very thorough recitation and review of the board's findings and finding that the board had lawfully and appropriately considered those 3 factors in the bylaw. As such, Your Honor, we'd ask that the trial court, this court affirm the trial court's decision to dismiss this case for lack of standing, correctly find that the trial court appropriately denied Ms. Costa's late request to file an amended complaint, and also find that the trial court correctly found that the board gave full consideration to the relevant bylaws.
Okay.
Nothing further.
Thank you both.
Very much.
Another really interesting case, and you guys kept up with the standard by the criminal lawyers. So we're going to take about a 15-minute break, and we'll be back for the 5th case, the Koozma matter, after that.
All rise, please.
Thank you. We're back on the record for 25P556, matter of Kuzma.
Thank you. Good morning, Justices. May it please the Court, my name is Stephen Hemingway, and I am here on behalf of the appellants.
Could you move the microphone a little closer to your mouth?
Absolutely. The appellants appeal from an adverse summary judgment decision at the probate court fiduciary litigation session. They appeal on two distinct issues. The first being whether or not a protected person under a conservatorship retains the right and power to execute their own will absent a court order. The answer to that question is found in the conservatorship statute itself by its plain language. Chapter 190B, Section 5-407, D, which states after full hearing and upon determination that a basis for an appointment exists with respect to a person to be protected, the court, after making appropriate findings of fact, the court has all those powers over the property and business affairs of the protected person which are or may be necessary for the best interests of the protected person. So the court has all those powers, and those powers include...
But if Mr. Kuzma was competent to make a will and didn't, under the conservatorship, give up that authority, how is it in his best interest under this statute for the court to take on that power?
Well, he does give up that authority. He does give up that power, and he gives it up via this statute. The same way he gives up the power to make gifts or make a trust to put all his property in. If the protected person reserved those powers for themselves, that defeats the entire purpose of a conservatorship. You can't manage your financial affairs, but go ahead and give it all away or put it into an irrevocable trust. It makes no sense. The old statutes, the appellee argues that capacity is all that matters. And all the cases cited, a handful of them, are from decades ago prior to the MUPC, under the old statutes. The old statutes are at the Chapter 201, Section 38, at page 45 of appellant's brief. The second paragraph, the probate court may authorize such conservator to exercise all powers over the estate that the ward could exercise. So the language there is different. It doesn't take the powers and give them to the court. It says that the court can authorize a conservator to do something that a ward could do. In paragraph 3, such action or application of funds may include, so not does include, but may include the making of gifts, and it lists several powers, 6 of which are found in the new statute, numbers 1 through 6. The 7th of which, the power to make or revoke a will, does not appear in this statute. Nowhere in here is an estate plan or a will ever discussed. So the cases decided on this statute, of course they're going to say the protected person has the power to make a will. No one else has it. The court doesn't have it, and it can't be given to the conservator absent a separate petition. But in 2012, the MUPC was enacted, and it was enacted wholesale.
Since 2012, has there been a case that's interpreted this the way you're asking us to?
There has been no case that's interpreted one way or the other. This case, I like to think I'm a good researcher, was unable to find a single case that addresses this issue since 2012.
What about in other jurisdictions? It's the same.
I couldn't find anything in other jurisdictions either. But the new statute is very clear. So, sorry, in enacting the new statute, in enacting the MUPC, all these old statutes were explicitly repealed. Sorry, they were explicitly repealed. You may have seen in the lower court order, the trial justice says, well, in the absence of explicit language saying the protected person, that the old statutes cases are overruled. I have no choice. But there is explicit language. They repealed them. They repealed the statutes on which those cases are based. And they enacted a brand new statute. And they didn't just take the language and the items from paragraph 3 that the conservator has the ability to do and write them into the new one. They added a whole new power, the power to make, amend, or revoke the protected person's will. And that power is reserved for the court. The court can then delegate that power on petition to the conservator or reserve it on petition for the protected person. We know this as several ways, one of which is that there was a limitation of power, a reservation of power for Mr. Koozma in this case. His court-appointed attorney, 2 months, just over a month before he wrote this, before this will was executed, his own attorney went to the court asking to amend the decree specifically to reserve powers, certain powers for Mr. Koozma. One of those powers was the ability to make a gift. So apparently, items on this list, you have to go to the court and ask for that person to retain the power to do it. None of those powers were the ability to make a will.
So are you,
Sorry.
the argument about capacity,
Yes.
are you still making the argument that because he was in a conservatorship, there's a capacity issue?
I've actually never made that argument. I don't think the case law supports that. In fact, the conservatorship decree specifically says right on it, this is not a determination of capacity, as does Section 5-407. On Section F, a determination that a basis for appointment of a conservator or other protective order exists is not a determination of incapacity of the protected person. Yet they still say, two subsections before that, that the court has the power to make, amend, or revoke a will. Capacity has nothing to do with it. You can be capable of making gifts, but you still have to ask the court because your property is under protection. The making of the lower court and the appellee cite the bare bones one-sentence statute that anyone over 18 may make a will. Great. And then these other statutes carve out exceptions. You can't disinherit your spouse. You can't make a will that goes contrary to the order of a divorce court or other court ordering you to do whatever with your property. A conservatorship, by its very nature, takes away property rights from the protected people for their best interests. And the court has those rights and gives them to the conservator as may be necessary, or reserves them for the protected person as may be appropriate.
But here, it wasn't given or reserved.
It was not in this case, no.
Okay, so then what's the status? If it's not given or reserved?
The court maintains the power. You have to ask the court. It's evidenced in the the probate court, in the guardianship, removed the appellee, who was Mr. Koozma's conservator. They removed him in September of 2021, so a year and a half after the will was written. And that is in the appendix. The findings of fact are in the appendix at page 413. And the lower court stated that appellee is not suitable to serve as a conservator and therefore is removed. In support, the court relies upon the findings of fact before, which include the following. And then Section C says, Mr. Koozma's lawyer presented a will to Mr. Koozma that was drafted by Mr. Tamkin's lawyer, which named Mr. Tamkin as personal representative and sole beneficiary. The estate was reported to be worth $3.5 million. Mr. Koozma executed the will while under the conservatorship of Mr. Tamkin without notification to or approval of the court. So the court thought this was done under his watch without notification to or approval from the court, and that's a sufficient reason to remove him because the court understood that the process is laid out in the statute and that no one had done that.
I was going to go back to Justice Singh's question then. You're not making a lack of capacity argument. You're not making any argument that the will that was executed is not the true desire of Mr. Koozma. You're just saying that he didn't have the ability to do it. He had to go to the court to do it.
Yes, that's exactly. We have no evidence.
Okay, and so I mean, and I assume your end game is that if he didn't have the power to make it, then he died intestate. Why wouldn't the end game be that the court exercise substitute judgment to determine what the will would be, just like in Olson?
Fair enough. Well, in that situation, you have a that was I believe a conservator that created a will.
Right.
So the the validity of the will was not at issue. Neither was the ability of the person who had the will created to make the will. They just simply didn't apply for court approval. So they were going back and applying for court approval, if I recall. Whereas Mr. Tamkin, in the almost 2 years from the creation of the will, through the court hearings, through the removal of him as conservator, with the court's warnings that this was done, up till Mr. Koozma's death in 2022, did not ever go back and apply to the court for validation, I'm blanking on the word, ratification of the will. So that there is a difference there. If someone dies intestate, if they don't have the right to make a will, it's great that their wishes are known, but if they die intestate, that's functionally it. Like you honestly can't, unless without the consent of the warring factions, I suppose. You don't see a compromised will spun up whole cloth by a judge out of nowhere when there's nothing even seemingly valid on its face to rely upon.
Could you address the second issue?
Yes, the second issue is validity in the execution, validity of the document itself. This was actually not addressed by the lower court.
What was it raised? Was it raised?
It was raised in the summary judgment papers, perhaps ruling on the underlying. I'm not going to speculate as to why, but it was not addressed. And what it does is it creates a question of fact. And so ruling that the adverse to my legal question is one thing, but ruling that the will itself is validly executed is a whole other issue. And the argument there is that Mr. Koozma's will was signed by his court-appointed attorney, signing Mr. Koozma's name and indicating such. So he did. I believe he wrote by Craig T. Spratt, and then the two witnesses signed as witnesses, and their signatures were notarized by Mr. Spratt, by Attorney Spratt. So as a notary public, he's notarizing the signatures of witnesses saying that they saw him commit an act and write a signature. The notary statute allows attorneys to act as notaries in documents in which they're named in a fiduciary capacity. But he was not named in a fiduciary capacity. He just indicated that he signed the document. It's sort of a self-serving notarization. It's defective. With the self-proving affidavit defective, the will needs to be proven. And the statutes say that testimony of at least one witness needs to be submitted in order to support the will. In this case, only one of the witnesses was deposed. I could only locate one of them. And in her deposition, she was asked specifically, did you see Mr. Spratt sign the will? And the answer was no. No, I don't recall. And, did you see Mr. Koozma indicate to Mr. Spratt that he wished for him to sign some way? A blink, a nod, what? I don't recall. And in fact, at first, she testified that she saw Mr. Koozma himself sign the will. So the testimony is lacking, and there's a fact question at least as to that. And so I think it was improperly granted on that basis. If I may, one more moment, unless there's questions, I apologize. The issue, the appellee brings up the issue of waiver of that issue. That issue was waived as it wasn't brought up at the pre-trial, or was waived at the pretrial explicitly. If you look at the appendix pages 606 through 614, that's the portion of the hearing transcript where that issue was discussed. The probate judge did ask, he was talking about summary judgment. He wasn't talking about the trial at large. We were discussing the upcoming summary judgments. And his question to me regarding, the laser focus of the summary judgment is the question of law, correct? And yes, the answer is correct. The appellants did not bring up the issue of the the technical execution of the will in summary judgment because that's not a summary judgment issue. So we didn't apply for summary judgment on that. So my statement was correct. in that our laser focus was the question of law. The appellee, in his cross motion for summary judgment, sought to find that the will was valid and validly executed, undue influence, all those issues. So in response to that, in our opposition, we did bring up the execution. So it was not something we waived at pretrial, and it was not something that we raised despite telling the judge we wouldn't. It was something that was brought up and was defended against.
Okay. Any questions? All right. Time's up, so thank you.
Thank you very much.
Good morning, and may it please the court, my name is Robert O'Regan on behalf of Robert Tamkin. I'd ask the court, in considering this appeal, to pay careful attention to the language in the Uniform Probate Code, particularly Section 2501, because as I hear my brother's argument and the thrust of the briefing, I find that it ignores what the legislature said when it adopted the MUPC, which is that the orders with respect to a conservatorship are to be limited to those necessary to enable the management of the protected person's assets, giving the protected person as much ability over his own affairs or her own affairs as possible. I'm not quoting, but that's the gist of the statute. The other part of my brother's presentation with which I disagree strongly is the idea that upon the issuance of a decree under a conservatorship petition, the protected person's ability to make a will goes into a state of suspended animation in the possession of the court, in which this particular protected person, Frederick Kuzma, he had no notice that this was a risk on the petition that was issued. The petition that was here said he had no intellectual disability. The statute says that a decree on a conservatorship is not a determination of disability. The undisputed evidence below by the lawyer and two witnesses, I take it, I'm sorry, the lawyer and the mental health professional, Dr. Gregg, was there was no intellectual capacity, there was just the residual effects of a stroke. And so my brother would have it that somebody who is able to meet the statutory criteria to make an estate plan, which is to have an understanding of the natural objects of his bounty and a general understanding of the nature and extent of his estate, and to know what he wants to do with it, that standard is automatically thrown out because in this instance you have a man unable to drive himself to a bank, difficulty communicating his wishes, fully capable of deciding what he wanted to do, but fundamental rights that the statute does not say he is to be stripped of are put in a state of suspended animation. So if he wants, anyone in this situation wants to do anything for the natural objects of his bounty, they then have to reach out, find a lawyer, because in this case he has trouble leaving a nursing home, go through a whole expensive litigation, because he needs help managing his day-to-day affairs. That's what the cases uniformly say. There's no case, we looked, there's no case that supports my brother's argument. The cases to the opposite uniformly say.
But all the cases that are cited are pre-adoption of the Uniform Code.
They are, but the Uniform Probate Code did not affect the standard.
Does it change anything?
It does not, well, it changes some procedural steps. It codified a little better the issues of a temporary and permanent conservator. It delineated, I think, in a better way, the steps for a conservator, if needed, to create an estate plan. But in terms of the fundamentals, it didn't change the standard for entering a decree for conservatorship, which is that the person needs help managing his or her day-to-day affairs.
But we're talking about just delineating the rights, responsibilities, the powers, right?
But we're not talking about the legal standard for the entry of a decree of conservatorship. My opinion is that did not change, and at no time has a decree of a conservatorship automatically meant disability to make a will. And they are two fundamentally different decision-making processes, as the cases talk about, and even as this case indicates. Because even in the summary judgment hearing, and even in the summary judgment papers, the objectors agreed he had testamentary capacity. They agreed to the natural object of the bounty. They agreed to everything anybody would need in order to have a will approved. And the only thing, which is what Judge Donnelly asked, is whether or not, just because Mr. Kuzma needed a conservatorship to manage his day-to-day affairs, he was stripped of the ability, and I add, without notice. Now, my brother relies on the statute, so let's pay attention to what the statute says. Section 5407, in order to deprive someone under conservatorship the ability to execute his or her own estate plan, Section 5407 requires notice, hearing, findings, and a judgment. Fred Koozma didn't get any of those. The only aspect he was given notice of was that there was a petition to which he assented because he needed assistance in managing his day-to-day affairs. Now, the ramifications of my brother's argument on the integrity of people who need help, on what the system might be required to do. So if anybody's under conservatorship because they are homebound, but still able to make all the decisions in the world, they just can't get out to do anything, so they get a conservator appointed for them. They need to initiate legal proceedings, to write a will, for a lawyer they know to come in and help them direct their affairs. What does that do to the court system? Think of the things that my brother's, the practical things that my brother's argument raises. But the most important thing is the standard for the decision-making or activity of the protected person are two different places. And
does the guardianship statute assume that the person under the guardianship is not capable of making a will?
No, because...
Neither guardianship nor conservatorship.
Correct. Because the standard of the decision-making is different. It doesn't mean someone under conservatorship or somebody under guardianship always has capacity. It means that unless there's a step taken for a determination that the extent of the conservatorship or guardianship goes to that point to have those decisions made by somebody else. And I would point out perhaps the most famous case is the one where the former king of Hawaii, who was under a spendthrift guardianship, wanted to do a will, and that was challenged. And the Supreme Court of Hawaii relied on Massachusetts precedent to hold that the estate planning he could make, because the standard for somebody who might dissipate his assets during his lifetime is different from the standard for making a will, which is...
Can I infer that the case having to do with the King of Hawaii was pre-Uniform Code?
Yes. Okay. I think it was former king at the time. But the concept is the same, which is that the standard to make the will is different from the standard to impose a conservatorship. Our position, it is very important to recognize that difference.
So what does it mean when the statute says the court has all those powers over the property and business affairs of the protected person?
It just means that if the court makes the findings that the protected person is at the point where that person is unable to exercise the decision-making capacity, that's possible. You could have somebody, and it happens, I take somebody in the increasing population of dementia who needs an estate plan managed. They didn't do one during the time before they were afflicted. They have assets that needs to be done. I submit that's what the statute contemplates. Upon notice, hearing, and finding, then the court may do that. And the court has a process. There would be a guardian ad litem appointed to determine what the best interests or the desires of the protected person might be. There would have to be a determination that the protected person lacked, right, the ability to know and understand the natural objects of his or her bounty, to have a general sense of his or her estate and what he or she wanted to do with it. But it would be possible to determine if the protected person were able to make the decision where that person would want the assets to go. And that's what that hearing would focus on. That's an entirely different issue from what we have here with somebody who, at the summary judgment stage, the objectors agreed had the ability to make all of those decisions. So to say, because he needed somebody, not to denigrate the situation, to run around for him and to chase things down for him and to make sure his affairs were in order because he had limitations from the stroke, that automatically takes away from him that piece of his integrity. Think about it. That piece of him. When the system's supposed to be doing something to help him, it takes all this away. There is no way from the reading of Section 2501 that this court could or should agree with the appellant's position here.
Did you address the second issue about the notary?
Well, first of all, the operative place for whether or not this was ever an issue is the affidavits of objections by 3 of the objectors. And if you want to read those affidavits of objections, which are in the record, I believe starting at page 27, you will see that there isn't a glint of an issue as to whether or not there was undue execution, and therefore it was not raised, it was not part of the proceedings below. We argue it was waived. It was waived because of what was said at the pretrial conference. It was also waived because it was never raised in the affidavit of objections, which is where the objectors frame the issues to contest approval of the will. But even if you reach that issue, it still fails. The argument still fails. Because under the notary statute, the fact of the matter is, Mr. Spratt had no interest in the estate whatsoever. He could, under the statute, he could have, and I submit this is effectively what he did, he could have recited in the notary acknowledgement, right, because the statute would allow, if the decedent or the testator was not able to execute himself, would allow for a notary to say what happened so that the testator indicated that is what he wanted but was unable to sign. That's effectively what Mr. Spratt did. And he did it in front of 2 witnesses who were there. There is no case cited for any proposition, at least that I could see when I read my brother's brief, that Mr. Spratt did anything incorrect, but it wasn't part of the case below. It's raised for the first time here. It wasn't in the affidavit of objections. It is nothing this court should address. My issue on appeal goes to whether or not this court should address any of the issues that are raised, because, as we argued below, the objectors have failed to prove kinship. The law is pretty clear. Each one of us in this courtroom would not be permitted to sign an affidavit that says a decedent was my cousin because we have a common grandparent. I know because it's me, signed under the penalties of perjury. The law is very clear. There needs to be third-party documented official record of kinship, and that kinship must be proven by official record. The attempt to do that was with photocopies of birth records of the objectors themselves. What was missing was any proof that of common ancestry to the grandparents' level in foreign records. My brother argues that there's a statute that allows this, there's a rule that allows this, but that's only with respect to domestic U.S. states. Foreign records are an entirely different matter. The leading case which we cite to is, at least from what we could say, is from Italy, where an attempt to prove kinship was totally lacking, and the attempt to do that by the claimants themselves, saying, I am a relative and here's a copy of what I say is the document, is insufficient. If that's the document, if that's the kinship, the obligation is to go to the Foreign Office, whatever it is, and get it certified appropriately, get an apostille, or however you might do it through the Hague Convention, but have that official record attested.
Why is that issue so important to you that you raise it as a cross appeal?
Well, one of the reasons is that it means the court need not address any of the issues that are raised on the appeal because the objectors have no standing to contest any aspect of the will. So that will dispose of the case on a second ground.
And does it work the other way around? If we decide against the appellants, do we need to reach the, on the merits, do we need to reach the issue of the standing?
If I could be candid, I'm afraid if you decide on the merits of the appeal, you will say, therefore, there's no need to reach the issue of the cross appeal because we've decided the judgment below is correct.
Yeah, and is that a problem?
Not for me.
Okay. Okay. Thank you. Appreciate your candor. Thank you both.
Thank you, Your Honor.
Another interesting and tough case, and we have one more. Uh, 25P859, Mandelbraught versus Boston Board of Assessors.
Good afternoon. Anthony Ambriano on behalf of the Board of Assessors of the City of Boston. The assessors appeal from a decision of the Appellate Tax Board granting a residential property tax exemption with respect to a condominium property in Boston.
Can I just ask you, has the city been ruled against consistently many times on this issue, or is this the only one?
Well, this is the only one I'm aware of where there are findings of fact have been issued by the board. And as the court knows, that is a prerequisite to taking an appeal. So there might have been, there's reference in this record to a decision with respect to this same property some years prior to this case.
And just another, just really preliminary, off the mark question, but there's nobody sitting over that table. In these cases, is there notice to anybody besides the affected parties? Like, does the Attorney General get notice? Is there?
No. Occasionally there are instances where there's an institution known as the Massachusetts Association of Assessing Officials, which is a group of assessors, and they communicate among themselves through newsletters and otherwise when there is a case of general interest. In this case, and I'm sure the court is aware, the monetary value of this particular case is not enormous. Nonetheless, every exemption is important to each municipality.
Right. No, and I'm sure that there are many residences in the city of Boston that are owned not by an individual but by a trust or an LLC or whatever.
That's true, and while I'm only speaking anecdotally from what I read in the paper, there seems to be a lot of investments in these types of properties.
And it seems to me your position is that unless there's a specific statutory allowance of a particular type of entity to get an exemption, they can't.
Well, I think the case law has been very clear for more than 30 years. For the residential exemption to be granted, the taxpayer must use the property as his or her principal residence. The term taxpayer has been the subject of several decisions of this court, as well as the decision of the SJC. And the word has been given the meaning that taxpayer is the person liable for the payment of the tax. In this particular case, Mr. Mandelbraut was not the record owner of the property, he was not the assessed owner of the property, and he had no legal obligation to pay the real estate taxes. So I think the board here clearly, the appellate tax board, clearly ignored, and I shouldn't use the word ignored, but tried to reason around controlling precedents in ways that are very unconvincing. To start with,
Yeah, could you, could you address why their attempt to distinguish Moscatello is not compelling?
yes, the board in its findings goes on for several pages talking about Moscatello and the sequence of events and when assessors may or may not learn of a fact. That is not the holding of Moscatello. The holding of Moscatello is that taxpayer means the person who is liable to pay the tax. And that is never addressed by the appellate tax board in its majority decision, though as the court is well aware, there was a very strong dissenting voice even at the appellate tax board. And
they point to the board's decision, the majority decision they point to the sentence in Moscatello that says it's concerned with the identity of the taxpayer being ascertainable. And you say, I mean, that's just dicta, or?
Just a dicta. There is discussion in Moscatello about what we might refer to as administrative burdens or logistical burdens on assessors, all of which are valid. But the fact remains that you have to have, the predicate is that the person seeking the exemption has to be the taxpayer. And that just does not happen here.
And does it have to be the taxpayer on January 1st of the year preceding which the fiscal year the tax will be billed?
For purposes of this particular statute, 5C, it has to be as of the assessing date at issue, which is the January preceding. Yes.
I have some questions about your jurisdictional argument. There was a bunch of places in the transcript where the clerk kept talking about the jurisdictional documents and marking those. And I understand from the ATB rules, well, in this case, the jurisdictional documents were the tax bill and the articles of incorporation of the LLC. Did the ATB have jurisdiction?
No.
So
I think the ATB had no jurisdiction for the same reason why the taxpayer here, for the same reason why the assessed owner here could not get the abatement, the exemption.
So
under 5C, the application for exemption can be filed by a taxpayer. The taxpayer is used in that same section, and every time the word has come up, the issue has come up, taxpayer has been held to mean the one liable for the taxes. Just one moment.
So
take your time, don't spill.
So the petition under formal procedure lists as the appellant Benjamin Mandelbrot.
That is correct, and he is not the assessed owner of the property.
Right.
Nor is he the record owner of the property.
So 58A Section 7, which as I understand it is the, what gives the ATB its authority, says any party taking an appeal to the board, hereinafter called the appellant, shall file a petition with the clerk of the ATB. So what's a party?
Well, I think, if I may go back a little bit, the statutes that govern ATB jurisdictions in these types of cases, the General Laws, Chapter 59, Sections 64 and 65. That limits the class of people who can apply for abatements, who can appeal from denials of abatements in general. 5C is slightly different, the one dealing with residential exemptions, because the timing is different. And the timing here was such that a person who applies for a residential exemption actually has even a little more time than the ordinary abatement process. But nonetheless, the person applying under 5C and the application for abatement or exemption is a prerequisite to appeal to the appellate tax board. So you have to have the right entity filing the abatement application and then the right entity appealing.
So if an entity files the abatement application that is not the correct entity, you're saying the ATB should just dismiss or disregard or say we don't have jurisdiction, as in the Suffolk Law School case?
That is correct. And in this particular case, we have the specific, it still comes down to the specific word taxpayer. Who is the taxpayer? Who is eligible to be a taxpayer? And certainly Mr. Mandelbraut was not. He had no liability for the taxes, not the owner, not the assessed owner.
Don't we have to say that the ATB is wrong on the merits to say that there's no standing? I mean, it's...
Yes, and quite honestly, if I were to say my preference,
I asked the other people. Right?
The court should rule on both, and say that.
It's got to be.
Did not qualify as a taxpayer, which means, by the way, also didn't qualify as a valid applicant.
So it's going to be whatever it's going to be the same decision on both, with whether yes or no. It's going to be the same.
That is correct.
So I noticed in my travels through the ATB rules that right around the time in January 2024, they changed their rules. And one of the things they said is that an individual can appear pro se on behalf of an LLC in the ATB. That doesn't fly in an appellate court like this or the SJC. Is this something that's happening a lot with LLCs and people wanting to represent LLCs pro se?
No, and I don't believe it happens very frequently. And again, there is a difference between a party being eligible to represent a case on behalf of an LLC and that person having standing.
Right.
To be the proper party to the proceedings.
But part of the reason I'm focusing on representation is because it feels odd for us to be making a decision without someone sitting at that table, especially if the decision may involve sort of bombshell things, possibly, like the ATB doesn't have jurisdiction.
Well, I guess we all take the cases as we procedurally find them.
Mm-hmm.
In this case, for whatever reason, Mr. Mandelbrout elected not to proceed before this court.
It's for a few $1,000s. It's not worth paying a lawyer. But so there seems to me there's an undercurrent, if not an overcurrent, that he's taken advantage of the LLC form to get, to protect him from personal liability or something like that. And but he's also trying to take advantage of being an individual. What is the advantage of owning as an LLC that makes it like not fair for you to get a residential exemption?
Well, I think quite frankly, we just have to look at the statute. The statute says taxpayer. As the court knows, there was a decision in Bourne in the Cambridge matter involving the residential cooperative. And the legislature apparently looked at that decision and said, you know, this isn't quite right, we're going to change this. Mm-hmm. And the law was changed. But in the 30-plus years since Moscatello, and even more years from the decision of the SJC in Kirby, there's been no legislative activity to expand the residential exemption to those types of entities. And I will point out, too, that one of the things that the ATB said, which I think would be troubling to anyone who practices corporate law, the ATB looks at a definitional section in income tax law and says, well, and the definition says, well, a disregarded entity is an entity that has disregarded for tax purposes and all of the assets, income, expenses flow through. Well, that's a definitional section. And the ATB takes that section and then says, and I believe this is a quote, so for practical purposes, the ATB says, the owner of a pass-through entity, sole owner, is the actual owner. That's a rather startling concept, I think, in corporate law.
So when they say there's no mystery who really paid the tax and it's Mandelbraught, so if this were an LLC that owned more than one property, their decision might be different?
Well, I don't know what the ATB's decision might have been different, but the record is it only owned this one property.
It's got an address in Pittsfield and a mailing address somewhere else in Boston?
Yes.
Would the rule be the same if the property was owned by like a real estate trust? The real estate trust couldn't take a personal exemption?
No, not on the Moscatello. It's the same. There has to be legal ownership in the entity eligible for the exemption. I think that's the bottom line. And my time is up. Thank you.
Thank you. Another interesting case. And that'll conclude our sitting today. I want to thank the court officers and the clerks, and we'll be in recess.